Well, good afternoon. Welcome to the launch of our report on the UK Public Health Emergency Powers. Our commission, I should say our independent commission, was set up as a result of the initiative by the Bingham Centre for the Rule of Law with support from various supporters of the centre and funders. A PDF of the report and a link to the written evidence page was emailed to you all earlier this afternoon, and a number of printed copies of the report are available here. So they're all there. The report, it looks it's really quite chunky. Don't be put off by that. It's mainly pictures. But anyway, there it is. For those of you who don't know me, I'm Jack Beatson. I've had the privilege of chairing the team of 13 commissioners, 11 of whom are here. We've worked over the last 18 months looking at the way that emergency public health legislation was made, how it was scrutinized by the legislature, how it was used and enforced in the 4 UK nations during the pandemic. We've received written and oral evidence from those with expertise in lawmaking, public health, human rights, from all parts of the UK. We've been quite alive to deal with the UK government element, which was effectively an England and Wales element, and the devolved ones. And we've also collected evidence about the use of emergency powers in 10 other countries. I start with a number of very warm thanks. First to Hannah White, one of our commissioners, and the IFG, for making it possible to launch our report in these splendid surroundings. I mean, we should all be so lucky to work in surroundings like this. The Bingham Centre provided project management, assistance with research, and secured the funding, in particular from one of the Roundtree Trusts, the JRSST Charitable Trust. I always wonder why they have an acronym. I mean, they're not really identifying themselves very clearly. But anyway, we're very, very grateful to them and to the other funders, of whom there are a number. Thanks are also due to the Bingham Centre's staff, in particular to Lucy Moxon and to Katie Lyons, the project's research leader, whose dedication and skill has been absolutely outstanding. Last but not least, thanks to my fellow commissioners, they're leading experts on public health legislation, legislatures, governments, legal practice and scholarship, and public engagement. They were very generous with their time and expertise. Their contributions at plenary sessions, which were lively, and in other exchanges, were invaluable in producing a report that I think reflects the different professional perspectives which are necessary for an understanding of this topic. My task today is to highlight our aims and recommendations, to introduce the 4 other commissioners on the panel, who will each speak for about 10 minutes before we take questions from you. All the commissioners who are here, and they're in the front row, together with Katie, will participate in the Q&A session. That is not compulsory, that is, they have an opportunity to do it. The panel is, starting from my right, Ruth Hussey, who was Chief Medical Officer for Wales until 2016 and is now a non-executive director of the NHS Integrated Care Board in Cheshire and Merseyside. She's going to speak about our methodology and how public health perspectives were brought into our work. Then there's Joelle Grogan, Dr. Joelle Grogan, Head of Research at UK and a Changing Europe, which is based in King's College London. She will speak about what we learned from the comparative research and evidence about the approaches used in the 10 other countries. On my left is Adam Wagner, barrister at Doughty Street Chambers and the author of what became a very popular book. I doubt he made his fortune on it, but it was a very popular book on what happened in the emergency state. And he will speak about our work and findings on the legislative options. And last but not least, in any ways, the second, we finished with a Ruth, Ruth Fox, who's director of the Hansard Society, and she's going to speak about our work and findings on parliamentary oversight. I should mention that Ruth Fox and Adam will shortly be discussing the report and how it fits into the Hansard Society's wider review of the delegated legislation system at Westminster with Mark Darcy in an episode of the Hansard Society's Parliament Matters podcast. Our aim was to assess how far our current legislative frameworks and parliamentary procedures protect the rule of law and human rights and provide accountability, transparency, and parliamentary control, while, importantly, enabling quick action to secure timely and effective health outcomes. We wish to make recommendations in time to inform the UK and Scottish COVID public inquiries and government planning for future health emergencies. I think we've done it in time for the public inquiries. They seem to be still hard at it. We've had regular contact with the inquiry teams, and we've also developed fruitful relationships with policymakers in the UK and devolved governments and legislatures. Our recommendations focus on the design of legislation, including the protection of human rights, the enhancement of parliamentary procedures, and the improvement of legal certainty, and also the appropriateness of enforcement action. Taking each in turn, on the design of legislation, we reject both the suggestion that we should have an entirely new Public Health Act and that the Civil Contingencies Act 2004 would generally be a suitable legislative tool for responding to public health emergencies. And instead, we conclude that the powers available to ministers in England and Wales in the Public Health Control of Disease Act 1984 and the equivalent powers available to Scottish ministers in the Public Health Scotland Act 2008 provide a useful starting point. But it is a starting point in our view because we had significant concerns about the extent to which that framework provided for appropriate parliamentary scrutiny and oversight of government lawmaking and how far it safeguarded human rights and equality considerations in an emergency. And we propose amendments to address those concerns. And one of our key recommendations is that power to make public health regulations without prior parliamentary scrutiny should be restricted to where, after consulting the relevant chief medical officer, government has declared and the relevant legislature has confirmed that there is an urgent health situation, and that such declaration should be subject to a 2-month sunset period, after which it could be renewed. If the overall approach we recommend is taken in Northern Ireland's anticipated new public health bill, the result could be a largely consistent legal framework across the UK, which I venture to say would be a good thing. We also review primary legislation enacted during an emergency in order to respond to the specific threat, such as the Coronavirus Act 2020. We discuss the way in which parliamentary oversight of such legislation might be enhanced, notwithstanding the fact that everything has to be done very quickly. Our primary recommendations are that government should provide evaluative reports on such legislation regularly, we say every 2 months, and that there should be a non-extendable sunset period of between 9 and 12 months, after which new primary legislation could be required. The whole thing could be continued, but it would need an act. On parliamentary procedures, the report explores how those can be adapted to provide appropriate oversight of emergency responses by legislatures. We focus on 3 topics: making committees more effective by appointing a specialist committee to oversee the response to a public health emergency. Secondly, ensuring that adaptations to parliamentary procedure are made in consultation with members of the legislature from all political parties, and that they're not abandoned too swiftly following the end of the emergency period. And thirdly, improving parliamentary involvement in government contingency planning, including dialogue and cooperation between the UK Parliament and the devolved legislatures. As to legal certainty, the report focuses on 3 areas of uncertainty that arose in the pandemic. Uncertainty by the manner of making and the frequently amending large numbers of public health regulations. Uncertainty caused by the way legal requirements and public health advice were communicated by government, often at very short notice and without clearly distinguishing between the two. And thirdly, uncertainty resulting from differences between the responses to COVID-19 in the 4 nations. We suggest ways of ameliorating these problems. Finally, enforcement. We consider whether public health restrictions should be underpinned by criminal sanctions as a matter of principle. We then consider enforcement mechanisms used during the pandemic. We were particularly concerned from the perspective of the rule of law about the way in which fixed penalty notices worked as a tool for enforcing coronavirus restrictions. Our concerns included, I seem to have 3 of everything, 3 concerns. 1, the complexity of the offences for which fixed penalty notices were issued, more complicated than whether you were parked on a double yellow line. The high monetary penalty for some offences. And thirdly, the absence of a formal appeal mechanism. We were also concerned about the proportionality of enforcement of restrictions on people's protest rights. And that's an issue which arises in many contexts. We make recommendations for improving these matters in future public health emergencies. So that's my introduction. I'm going to hand over to Ruth Hussey now.
Thank you very much. My part of this is to just reflect on the public health situation that we faced and the position that we took as a commission, but also talk about the methodology that we used to come to the conclusions that we've come to today. And I think it's fairly obvious to say that COVID-19 pandemic was the most challenging public health emergency the United Kingdom has faced in generations. I was involved in working with local multi-agency response teams in the very early phase, and it became quite clear that what we were facing, the nature and the scale of it, was outside all of our collective experience. So just to put that back in context, remind you of that situation that we found ourselves in over 4 years ago now. And as you know, one of the steps taken by all 4 nations to control the spread of disease was to use legislation. And now is an appropriate time to reflect on whether the legislation, the use of it, the nature of it was optimal. And it's important that we do this. It's not unusual to review legislation. In fact, the 1848 Public Health Act came following a huge outbreak of cholera. So there's got historical precedent to do this sort of work. But it's vital that we learn lessons from to inform future public health action, recognising, though, that every situation that we face will have its own characteristics, things that we won't have anticipated. So you need flexibility as well, knowing that we can't plan for everything. So the tone and the style that we took was a recognition throughout our work that governments must be able to act quickly in an emergency to secure timely and effective public health outcomes. And in fact, really, it's been argued that this is an obligation equivalent to the responsibility for liberty and security, that we must protect the public's health. But in fulfilling those obligations, it's also clear that governments must do so with a balance of perspectives, using the best possible evidence that engenders public trust, and that the impact of specific disease threat is minimised with the least impact on other aspects of society. So that was the sort of position that we started off our inquiries. In terms of the scope of the work, we were very mindful of the UK and Scottish inquiries, and so there was discussion to ensure that we complemented what was being covered there and we didn't duplicate anything. We also, as Sir Jack has said, wanted to work very quickly so we could feed into their deliberations. So there are a few areas where we've gone in perhaps more depth and covered more than the 2 inquiries. For example, neither of the inquiries is focusing on the detail of public health emergency legislation from a constitutional and a rule of law perspective. Neither inquiry is considering the parliamentary proceedings in detail either. My understanding, I'm informed that the UK inquiry is proceeding on the basis that parliamentary privilege applies to its work, although, again, I'm informed that it hasn't made a ruling on this as yet. We have considered parliamentary proceedings in all 4 nations and in detail from a constitutional rule of law perspective, and including reviewing chamber debates, committee reports and meetings and so on. So we've gone into that into some depth. We've done less of other things, particularly 3 areas. We have touched on intergovernmental relationships. It was inevitable because we took a UK perspective on things, and we do make one recommendation in the report and some observations. But we haven't gone into it in detail because this is at the heart of the UK COVID inquiry's terms of reference. We've also not reviewed the impact on the justice system, again, part of the UK inquiry's work. And in general, we haven't looked at the non-pharmaceutical interventions that were applied during the pandemic and the impact of these interventions specifically. However, we have obviously considered them because it helped us to understand the breadth of emergency powers that were available and also the current safeguards around their use. So that's the sort of scope and how we narrowed down things to make sure that we were complementary. In terms of the method we used, I think it's a pretty standard method. Written reports, published work, committee reports and so on. We invited stakeholders to give evidence, both oral and written. And with the immense talents of Katie, especially, synthesised all the documents and the evidence that we received, deliberated as commissioners and produced the report you see today. So hugely grateful for the work she did. In looking at the evidence and debating what we received, we worked in 3 groups, and you're going to hear more about these 3 elements. So firstly, we looked at public health emergency powers in jurisdictions outside the UK, mostly focusing on 10 countries. And they were chosen because of their similarities to the UK parliamentary system, the efficacy of their legal response from a rule of law perspective, and an assessment of whether they were in line with the scope of our work. The second group focused on public health emergency legislation in the UK, looking at both the framework legislation designed that we had in place to deal with public health threats, but also, as Sir Jack said, the response to the COVID-19 pandemic, considering how far human rights and equalities are safeguarded, and reviewing the criminal enforcement of emergency public health laws. So that was Working Party 2. And the third group reviewed parliamentary procedures in the UK, Scottish and Welsh Parliaments and the Northern Ireland Assembly, looking at how far they were able to provide appropriate scrutiny and oversight of lawmaking during COVID-19. And we're going to hear more about all of this, and looking particularly at the adaptations of parliamentary procedures to facilitate operation during a public health emergency. So in terms of the evidence, we sent out a very wide trawl calling for evidence to over 200 stakeholders, all sorts of backgrounds, parliamentarians, officials, public health practitioners, professional bodies and academics. We received 34 responses. We didn't make a call for a public call for evidence rather, partly because it's a very specialised focus of our inquiry, partly the limited capacity we had to consider the material, and also the fact that both of the COVID inquiries are also actively seeking public input into their deliberations. So we heard oral evidence from 14 individuals with regard to the international comparative work. We heard from 19 witnesses in the UK with experience in lawmaking, governments, parliaments, public health, policing and human rights. And we also received a few more follow-up written submissions from people who either couldn't come in person or gave us even more material afterwards. So quite an extensive detailed response from a number of people. And we deliberately set out to reach out to lots of different perspectives. We wanted to make sure that we had a broad range of views, both political views and affiliations as well. I should mention, though, that some public servants really didn't want to engage with us at this point because of potentially a perceived conflict of interest with the public inquiry, and particularly perhaps those who are preparing their own evidence for that purpose anyway. Having synthesised the material that we had and the inputs, we did actually test and discuss our emerging findings with senior officials in the four nations. And we also, when we had got to the point of draft recommendations, reached out to a wide range of stakeholders, again, a cross-section of respondents, to make sure that our recommendations had resonance and were suitably applicable. So you're going to hear the detail of those recommendations now from our three next speakers. My final comment, the COVID-19 pandemic brought into sharp relief the tension between controlling spread of disease, an unknown disease with unknown quantity of harm, we didn't know much at that stage, with the role and power of state. And I hope by reviewing the legislation and its application, we can prepare for the next public health emergency in a way that means we've learned what works best, and we're able to deal with that situation with full public engagement and support for whatever comes next. So thank you, and I'm going to hand over to Joelle.
Thank you. I'm going to begin by echoing so much of the gratitude that I feel as a commissioner to be part of this, but also to the dear leadership of our great leader, Jack, on my left, and also the incredible work of Katie. I know that we're all going to be looking over at her constantly and just expressing such gratitude for her work. She and Lucy were just absolutely phenomenal in the preparation of this very sizable, if not intimidating, report. I speak on behalf of the International Comparators group and the work that we're looking against specifically at those 10 countries. But it was also certainly drawing from the analysis of the fantastic work of Jeff and the Lex COVID Atlas, which drew on far many more countries throughout the world in that context. Just to name those 10 countries, as I think it's relevant to understanding not only the scope of what we did and how relevant it was to the immediate considerations that we had specifically in the UK, but also just at the kind of comparative work that we were doing at that international level. They were Australia, Belgium, Canada, France, Germany, Ireland, Israel, Italy, New Zealand, and Norway. So again, drawing both from common law systems and also civil law systems. Again, just to echo what we heard in the context of methodology, this was based on both my and Jeff's work on comparative COVID comparative COVID studies, and also how relevant they were both to the immediate UK parliamentary system, but also how effective they were against the metrics that we were looking for as to what made a good COVID response in the context of rule of law and human rights considerations. What I would say is, in just this brief opening remarks that I'm going to give in the context of the international comparative work, I will talk a little bit about the overarching themes that just became apparent to us in this work, before giving a little bit of the backdrop of some of the findings that we might draw from this comparative research. Really, though, leading into what were the key findings that are going to be on my left. So we have methodology, we're going to have some international flavor and backdrop, but really we're going to be looking at the findings then. First, just in terms of overarching themes, I always feel that it's necessary to emphasize that nowhere in the world was there a perfect response. Nowhere in the world can we point to a single country and said, they did it perfectly. One of the fascinating things from an academic perspective, but deeply, deeply, deeply concerning and reflecting the reality of a pandemic situation, is that it was a simultaneous crisis throughout the world. It was almost simultaneous response throughout the world. And that we saw exposed in every single legal system both the vulnerabilities of governance, the vulnerabilities of health systems, the vulnerabilities of legal systems and decision-making at all levels of society and all levels of government, but also their strengths. What became apparent in the ways in which different countries responded legally through their legislatures and through their parliamentary systems and through their decision-making systems as to what was effective against, again, those metrics of rule of law that was so important to countries throughout the world, especially those that we looked at. So one of the opening points that I would emphasize is just the recognition of how important it is to look beyond the UK, to look beyond the countries and the states that we're familiar with to really have that mutual understanding of what makes an effective response, and even where there is an ineffective response, why, and the importance of mutual learning and mutual understanding. Within that context, there were commonalities that we kept seeing throughout the world. The first was always the suitability of the drafted legislation. Often the legislation that was being used in the context of a very, very different problem. So many times in other countries, we saw that the law that was initially being reached out for was with a very different epidemic or pandemic or health situation in mind. Classically, HIV in Norway, that was one of the first that was relied on. Or often we saw the same kind of rule of law issues that we became so concerned about here in the UK. For example, where legislation had been drafted to give far too much discretion to government. The concern that where there is a pandemic or a global or a health situation that is unknown, it is best to concentrate power and let that power be used as immediately as possible. The second element that really became apparent was the necessity of having very good balancing factors. So the idea of having efficient or effective parliamentary scrutiny of executive powers or consultation between different levels of government, that this is something that, again, emerged as an important consideration in other countries when they were trying to expand and decide what their response should be. And when we were looking at international comparators for, again, these key lessons for our own context, we tried to look at those debates and those understandings and how they tried to respond to those questions. A final just overarching theme that was, again, became apparent is the idea of having a holistic approach, having a whole system understanding. That I know that it's so tempting, and I do this certainly when I do comparative work, of just focusing on one element and thinking that this kind of sticker or this procedure could easily be copy-pasted into our own and then everything would be fixed. But instead, understanding the entire system and how it can relate, that each part relates to others, to understand the strengths, weaknesses, and potential operation of any approach that could be developed. But ultimately that it would be reflecting the interdependency of so many issues, that we cannot have effective parliamentary scrutiny of emergency legislation, of emergency declarations, if we don't have a broader understanding of the relevant political and constitutional considerations that go into that. I'll be giving some examples of that, but essentially you can't have effective intergovernmental discussion if there's a breakdown politically, if there's no trust, if there's no cooperation, if there's no pre-existing system for intergovernmental cooperation. It cannot be created in an emergency. The kind of effectiveness of legislation and the effectiveness of institutions, the effectiveness of decision-making processes must be developed before for it to be effective during. Those are general considerations, but some of the key findings, and again, this is going to be a taster for the exciting recommendations that will appear on the other side of Jack, our great leader, is to first have, I think I'm drawing about 5 or 6 in the few minutes that I have left. But first we looked at intergovernmental cooperation. We looked at the institutions, the bodies, and the structures that exist mainly in federal systems. So we looked at particularly Australia and Germany, and what went wrong, for lack of a better way of saying it. That initially we saw very good cooperation in the context of the federal systems of Australia, with facilitation of cooperation between different levels. But again, we saw that political divisions ultimately led to some degree of breakdown. That while Australia and Germany had very, very effective examples in their early stages of approaches, we saw as it continued some degree of tension emerging. But again, two good examples of where it is necessary to have trust and cooperation. But we did want to highlight the success of Belgium, surprisingly, and how the federal government did take a lead with broad consensus, but that the central government took powers that would ordinarily fall under local competencies, but the idea of creating a floor, not a ceiling, and how the communities and regions could have the ability to pose stricter restrictions. I'm suddenly realizing, even as I say this, that it would be more effective for you to read the report rather than me to give you these flavors. So how about instead I just tell you about the broader context of these key emerging findings rather than going into the detail. So what we thought about is what is essential in terms of the lessons that we can draw. And the lessons that I would say in the context of the final four is, first, where there's a declaration of a health situation, there was a clear majority of jurisdictions that did adopt it. And we can find that many of them used some form of procedure to grant this executive power for urgent decision-making, but that we almost have to seek the balance, the understanding of where parliamentary, where there is excessive power given in that context. Second, when we look at comparative information on sunset clauses, we must always seek the balance of understanding where it is necessary. And we observed in the context of certain countries that had far too long a declaration of sunset clauses, and also those that were too short. What we also then found was the importance of parliamentary committees and having specialist parliamentary committees, we found that they were generally effective in other states in providing robust scrutiny of executive power, but in countries where the committees acted as parliaments in miniature, they proved far less effective because they promoted the idea of having more partisan and less effective responses over time. So when we looked at the other countries, the idea of having specialist committees was a generally effective one. I'm realizing with horror that two of my points on comparative sunset clauses were deleted on the bus on the way. So there is a whole section of my fabulous speech that is somewhere on the tube. So I do apologize for sunset clauses, and I will instead ask that you specifically ask Jeff King on the point of sunset clauses, because the two paragraphs that are missing in the context of sunset clauses were drawn directly from his work, if not quoted verbatim from his work. So please do ask him about those. The final point that I do want to mention, and this is something that emerged as one of the critical elements that we spoke about almost constantly, certainly in my own research, and I looked at about 60 countries worldwide in COVID response, but also throughout the Lex Atlas encyclopedic information on COVID responses, but also within the context of the 14 individuals that we talked to, which was the importance of legal certainty. I know within the UK context, one of the debates that we had almost constantly was the confusion over advice or guidance versus law, because this is critical to the debates around enforcement. Because in the UK context, there was such confusion. And I know this is something that was debated, although in different ways in other countries, that New Zealand is a fascinating example, and I do encourage you to look at the New Zealand response. But it was ultimately less enforcement, but more reliance on the idea of principles and broad ideas and broad understandings and clear communication, but it didn't rely on enforcement in the same way, and we didn't have the principles in the same way. And one of the conclusions that we did come to in this group is we cannot see ourselves as in New Zealand. We cannot see ourselves as relying on broad principles, but we absolutely must have clearer communication. One of the critical elements that kept being exposed within the context of the COVID response is the confusion of the ordinary, not only in terms of police as to when something can and cannot be enforced, or when something is or is not unlawful, but also just in the ordinary actions of being. When can we go to a park? When can we not go to a park? Who can we meet? Who can we not meet? What is a bubble? What is not a bubble? So one of the points that emerged, and this is probably the final point while I get over the sheer embarrassment of, again, losing two paragraphs and speaking in front of you all, is the importance of speaking clearly and speaking effectively when you are speaking as authority. I proved my point by doing neither. So one of the final points of our international comparative work was how all countries were ultimately coming to the same challenge, which is when there is such extreme uncertainty as to the most effective response, as to the most effective regulation, as to the most effective law, we must always rely on the same principle, which is still clear communication, even while you try and search for the right, even while you try and search for the best, just to clearly communicate in your law and your legal principle. So on that dramatic moment and sheer embarrassment earlier, I'm going to pass to my colleague.
Over to you, Adam.
Thank you. I'm going to talk about the legislative options group. And this was really about trying to understand whether the laws that were in place and were put in place during the pandemic were fit for purpose and what we would do differently if there was another pandemic. And in considering this, and to pick up some of what's already been said, there was a number of tensions in understanding what is best in these situations. There's tensions between, for example, being the law needing to be agile and quick and responsive, whilst at the same time providing enough space and time for parliamentary scrutiny, for some kind of parliamentary scrutiny. There's a tension between the law having to be clear and precise, but at the same time able to change quickly. And that is not always a tension that can be resolved, because if laws are changing twice a week or even twice a day, no matter how clear and precise they are, there's a lag between when people can get to know the new law and when they'll be able to understand it. There's a tension between the law needing to be firm enough to encourage people to comply, and in some cases force people to comply, and at the same time be fair and be also mindful of the fact that the criminal offences that you create in the pandemic context might not morally or in terms of values be on the same level as other kinds of criminal offences. And that has to be taken into account when you're enforcing and when you are deciding whether to give some sort of sanction. And then a fourth tension is the laws the framework of the laws needs to be wide enough to allow for all of the different permutations, some of which are predictable and some of which really aren't, of the future public health crisis, but at the same time not give the state so much power and so much discretion that you effectively give too much power and too much discretion, and that can lead to abuses of power. And I suppose it's inevitable that no matter what you plan for, what comes along will be different. But I think, there's a expression that I sometimes think about in court, which is that in war, plans are hopeless and useless, but planning is everything. And that's really, I suppose, what you're doing with pandemic laws as well, that it's in the planning and in the creating of institutions, the thinking through on a fairly regular basis of different possible permutations that you create the sort of institutional competence to allow for lots of different scenarios. So in terms of our key findings, on the most basic level, we say the principal legal basis for any response to a public health emergency should be framework primary legislation, which has been designed and enacted outside of the emergency period. And that's no different to what we have at the moment. In fact, the Public Health Act was there at the beginning of the pandemic, and it was used to create regulations around it. That legislation should, as the Public Health already does, empower governments to respond to a variety of potential public health threats, including by statutory instruments, provide for appropriate democratic oversight and accountability of emergency lawmaking, help maintain other principles of the rule of law and good governance, should expire, we say, after 9 to 12 months, without being extendable by statutory instruments, and should be drafted after the widest practicable stakeholder consultation and engagement, and once passed, kept under periodic review, which is contrary to, or in contrast to, what happened with the Public Health Act, which was, with the Coronavirus Act, which was drafted, the bill was drafted completely without any public scrutiny as the pandemic flu bill, and then was sort of taken off the shelf at the beginning of the COVID pandemic. We absolutely recognise that any pre-designed framework is going to probably need to be supplemented by additional primary legislation to allow for the different kinds of scenarios that might emerge during a pandemic. We considered but rejected the idea that the Civil Contingencies Act would be the suitable legislative tool for a public health emergency. We think that that's wrong. It's wrong because the Civil Contingencies Act very clearly provides that if there is suitable legislation for the particular emergency, then it can't be used. And we concluded that the Public Health Act 1984 and the equivalent powers in Scotland were the right starting point for framework legislation. We proposed some amendments to the Public Health Acts, the framework legislation that exists at the moment. Probably the first one in order of what would happen in an emergency is that we say there should be an urgent health situation declaration. And that is that after consulting the chief medical officer in their jurisdiction, a minister must conclude that an infectious disease or containment constitutes or may constitute a danger to human health. And it's necessary to make regulations on an urgent basis in order to protect against that danger. And that should be laid in draft before being made, and the advice from the chief medical officer should be put before Parliament. And that effectively triggers the ability to use the more extensive emergency powers. We do have significant concerns around the extent to which the Public Health Acts provide for appropriate parliamentary scrutiny, and Ruth is going to look at those, so I won't deal with them. We looked at human rights and equalities and how they impact on the legislative framework. We received evidence about instances in all 4 nations where human rights and equality considerations appear not to have been properly taken into account by decision makers during the COVID-19 pandemic. And we looked at how best to address that, and particularly encourage or even mandate governments to consider equalities and human rights at each stage of the emergency response. We focus on improving government consultation and engagement with affected groups and independent rights institutions, and also discuss whether advice provided by the Scientific Advisory Group on Emergencies, SAGE, could be supplemented by advice on equality and human rights issues from a group of independent experts. And we recommend that when responding to a public health emergency, governments should convene or recognise a group whose function is, like SAGE, but for equalities and human rights, to provide independent advice on human rights and equalities issues. And that would be fed into the government decision-making as advice, just like the SAGE advice was. We also recommend that ministers have a statutory duty to have regard to any relevant advice produced by national human rights institutions in their jurisdictions when making or continuing a declaration of an urgent health situation and when laying or continuing public health regulations. And again, it's a check. It's a mandated check on what's going through the public health emergency system. On legal certainty, Sir Jack already raised the issues that arose over legal certainty, and they're very well known. They were very well extensively discussed during the pandemic. But the particular issue that we identified was that in order for people to understand what the law requires them to do, the legal rules must be sufficiently clear, stable and accessible, and should enable people to foresee with reasonable confidence when they might be sanctioned for not following the law. And that's basic principle of legality and rule of law stuff. And in Chapter 6, we identify 3 main areas of legal certainty. That's Sir Jack's already spoken about. We also suggest ways of solving the problems in a future public health emergency. First of all, avoid frequent and last-minute policy changes. No doubt that's already known to the policymakers, but just to emphasise that. We say legislation should always be consolidated after 6 months and then every 3 months thereafter to prioritise clarity and coherence and to mitigate the issues that arise when you have constant amending regulations arising every few days. We recommend that amended regulations should be produced with a document which shows effectively the track changes. So it shows how the legislation will be changed. And that was something that didn't happen in Wales, actually, to be fair, but not in England. Regulations should be produced at least 2 days before they come into force. And if published too soon before coming into force, so we say any less than 3 days, that should be taken into account when deciding whether to take enforcement action, because it's reasonable to assume that people would not know about the changes. Guidance, obviously the issue around guidance and law, recommendations, rules, restrictions, these terms which were used quite often interchangeably during the pandemic, that really needs to be tightened up in future to allow for people the public to clearly distinguish what is guidance, what is law, what does it mean, what do rules mean, what do regulations mean. And then finally on enforcement, you've already heard about the possibility of FPN appeals. We say that there should be a consideration of a pre-fixed penalty notice warning procedure, a greater role being given to environmental health officers or similar. We say it's not inevitable that the police are the right body to be, or the right institution to be enforcing emergency health regulations. And in fact, the police quite often were not necessarily the right body to be doing that, because they don't have an institutional understanding of public health, and when assessing proportionality, they need to understand on one side of the scale is the public health risk rather than the public safety risk, which is what they're used to. We say fixed penalty notices should generally only be for low amounts, and generally they were, but with the odd £10,000 or £5,000 fixed penalty notice thrown in for specific issues. And we say that if they're going to be exceptionally very large, so in the thousands of pounds, there needs to be good evidence first to justify that. We say national guidelines should be produced to control protests and other sensitive areas involving human rights, and that any criminal offence or enforcement power should explicitly specify that rights protected by the European Convention on Human Rights would provide a defence against enforcement or conviction. And we know there is quite often a reluctance to include specific reference to human rights protections in legislation that isn't the Human Rights Act or in the equivalent, the Equality Act. But we say that it's important, particularly for those enforcing the regulations, and in this case the police, to know that it's for that to be front and centre. And I'll just end also by passing my thanks on to Katie again, just so she gets the clean sweep of being mentioned by everyone. Ruth, you just got to remember that. So thank you very much.
Thank you. Well, I will also pay tribute to Katie just to make sure I cover it off. Good evening, everyone. It's nearly 6 o'clock on a Wednesday evening, and I can see the oxygen exiting the room, so I will try and make this as brief as possible. I'm going to discuss the parliamentary aspects of our work, and I think it's fair to say that the commissioners were agreed and recognised that in a national emergency, when time for normal scrutiny processes is short, the gravity of the situation can mean that we have to temporarily sacrifice the normal parliamentary scrutiny arrangements in exchange for after-the-fact oversight. But during the pandemic, we felt, during and in our deliberations quite strongly, that the concept of emergency was stretched and the role of parliaments, and particularly the House of Commons, I'm afraid, was marginalised to an unacceptable extent. So a core question that we as commissioners have had to ask ourselves is, what does appropriate democratic oversight and accountability of emergency lawmaking look like? And we were also cognizant that in determining what that might look like for the future, it shouldn't entirely be in response to how the pandemic this time unfolded, because in future the government context, the political context and the nature of the health emergency might be somewhat different. So it would have to be capable of applying to those different circumstances and contexts. I'm just going to talk very briefly about 4 aspects: delegated legislation, the parliamentary committee model, the process whereby the Parliament adapts its procedures in response to an emergency, and then just very briefly the role of a Parliament in contingency planning. But by way of context, I should say that the way that the problems that emerged during the pandemic in relation to parliaments were actually not new. They were existing problems, but the nature of the emergency and the longevity of it put those problems into stark relief and to some extent on steroids. And so, that's been part also of our deliberations, and that was never truer than in relation to delegated legislation. Mine, the Hansard Society's favourite subject. So I'm not going to bore you all with, bore everyone to death with details about the various procedures and go through each one in detail. We don't have time, but I'm just going to talk primarily about the made affirmative scrutiny procedure, because that was the changes to that urgent procedure that so underpinned some of the difficulties around delegated legislation during the emergency. And it brought to much wider public and media attention, and I think also the attention of MPs and themselves, that the extent to which ministers, and I'm very conscious that the minister, the former health minister, Mr. Hancock, is in the audience, but ministers with a sweep of their pen could impose regulations on us with little or no role for Parliament in the process. And every one of us felt the impact of that through the emergency, through the lockdown restrictions, through the travel regulations and so on. So in the report, we suggest a number of changes to that process to sharpen the way in which the urgent procedure in the Public Health Act, the made affirmative scrutiny procedure, can be used by ministers. Now, as it's currently drafted, that urgent procedure in the 1984 Act permits, frankly, excessive use of the procedure, whereby ministers can bring the regulations into force. Parliament then has to approve them retrospectively within 28 days or they will fall away. And it's important to say that procedure is not unique to that Act. It can be found in other Acts, but it's never been used to the extent that it was in that 1984 Act. Whether the circumstances of the emergency justify the use of the procedure is purely a matter for subjective ministerial judgment. He or she merely has to declare that it is urgent and the power can be used. There are no constraints on it. The Hansard Society, throughout the pandemic, we've been monitoring statutory instruments, all the statutory instruments laid before Parliament, and 20% of them to tackle coronavirus-related matters over a 2-year period was subject to this procedure. That is highly, highly unusual. I can't stress enough how unusual that is. The norm would be maybe 1 or 2 in a session. During Brexit, there were more, but we saw it, as I said, on steroids during COVID. And often the use of the procedure, frankly, was not justified by a lack of time. And one of the most notable examples you may recall was the decision to introduce face masks. That was brought in using that urgent made affirmative procedure, and yet it had been trailed in the media for weeks. And when the health minister got to the delegated legislation committee weeks later, she was asked what was the reason for the emergency? Why was it being used under this procedure? And she said, I'm not sure, I'll have to go back to the department and ask. So that was a kind of a demonstration of the fact that actually a different approach, a different procedure could have been used, which would have allowed advanced scrutiny. The government, I have to say, the government's casual approach to the scheduling of debates, particularly in the first 6 months of the pandemic, also exacerbated the problem. It meant that some of the regulations were in force for weeks before MPs could consider them because of this 28-day scrutiny period and taking into account things like summer recess, which delayed scrutiny. A succession of lockdown regulations saw MPs debating and approving instruments after they'd been amended by a later instrument. Some instruments were revoked before they were debated at all. Some came into force, obviously, just hours or less before they were made. So we need to recognise that the need for an emergency procedure, but we proposed constraints on its use to avoid problems like this in the future. So we suggest in the report the Public Health Act should be amended. It can only be used, or should only be used, if that urgent health situation declaration that Adam referred to has been triggered and remains actively in force. So that, in a sense, that declaration is the gateway to the use of the emergency procedure, and it has to be renewed. So it would mean that it can't be continued to be used by ministers over an exceptionally long period of time, as happened during the pandemic. The minister has to take into account relevant advice provided by a chief medical officer, and a written statement at a minimum has to be provided to Parliament to explain why the regulations are urgent. At the moment, the Minister doesn't have to give any explanation. There's a sort of statement in the explanatory memorandum, but that is all. And we propose that the number of days for retrospective approval by Parliament should be reduced from 28 days to 14, and if necessary, Parliament should be recalled, as is the provision in the Civil Contingencies Act for approval of regulations under that legislation. And if you want to use the made affirmative procedure and bring in regulations, they should expire after 2 months and should have to be renewed if you bring forward further regulations if you want to continue to use them. But if you do, then the Minister would have to provide some kind of evaluative assessment, impact assessment of their impacts on society, in terms of the nature of whether it's emergency health regulations or emergency transport regulations, whatever it may be. But they would have to give at least a basic assessment of their use in the first 2 months. We've got additional proposals in the report about the other aspects of the procedures, but I won't go into those now. We can perhaps pick those up in questions. Secondly, we propose a dedicated emergency scrutiny committee be established. Now, we recommend in the report this for only Westminster and Scotland, in part because we didn't have enough evidence in relation to Northern Ireland and Wales, and we're also cognizant that they are smaller legislatures and therefore there are capacity issues, but on balance I think they probably would benefit as well. And we felt that I think it's fair to say we had mixed evidence about the value of this, that some people who gave us evidence thought it had been a really good thing to have a specialist committee. Others, has to be said, particularly current select committee chairs or select committee chairs at the time we took their evidence, were a little more sceptical, though I think it's fair to say they had skin in the game and were sort of protecting their own empires. So we were cognizant of that. On balance, having considered it, though, we felt that the advantages outweighed the disadvantages of the idea. So essentially, we propose a specialist parliamentary committee would review and scrutinise government policy to the pandemic on a cross-cutting basis. Departmental select committees in the Commons, for example, do excellent work, but they wouldn't necessarily, in the context of a pandemic, be able to do the cross-cutting nature of the work that we felt was required. The declaration, again, that Adam talked about of the urgent health situation would be the trigger to establish the committee, the need for it. In a fast-moving situation, it could be convened to engage with ministers more quickly than sort of trying to convene the entire legislature. We suggest it should be chaired by a senior member of the opposition, and the membership could draw in members of those existing policy-related committees. Like other select committees, other parliamentary committees, you'd be able to appoint external advisors, not to provide alternative scientific or medical advice, but to help guide members through the complex thicket of sort of health and scientific information that many parliamentarians struggled with during the pandemic. Thirdly, the question of how legislatures adapt their procedures. How many of you remember the conga line of MPs lining up, socially distanced, ready to vote on Jacob Rees-Mogg's motion to abandon the virtual parliament? It was it was frankly an embarrassment and a complete mess. But we had a concern that the ways in which legislatures adapted their ways of working in terms of virtual and hybrid procedures, it had been very good. There was a lot, I talked very early on about Westminster having been a world leader in adapting to its virtual procedures. But then we found that they were abandoned very quickly and at the behest of the government with limited consultation. So, for example, at Westminster, we were particularly taken by the evidence that when the provisions around the virtual parliament, the use of it were restricted by the government, it had very little regard to the impact on smaller parties, and it had very little regard to the geographical implications of what it was proposing. It was very, should we say, London and South England centric. Consultation with the opposition parties was poor about the changes. Travel restrictions were still in place in Northern Ireland and Scotland, for example, when MPs did not have the range of options available to them for virtual procedures that they'd had previously, which affected the ability of MPs in far-flung constituencies to travel to Westminster, or if they based themselves in Westminster, to travel back to their constituencies. And therefore, the range of ways in which they'd previously been able to make representations and participate in proceedings was more limited. So in the report, we flesh out why we think it's necessary for sort of broader consultation and consideration of the implications of changes to procedure, how and why that should be done, and why that should flow through the relevant procedure committee of the legislature rather than just the government of the day. And finally, we recommend all 4 legislatures should be involved in future contingency planning for a health emergency. So if you think back to previous emergency planning through the Cabinet Office, sort of Operation Cygnus, for example, there's no role for legislatures in that committee work. But what COVID did do was demonstrate what a critical role the legislature plays in an emergency such as we faced with COVID, both in terms of debating and bringing about democratic oversight and accountability of the response to the pandemic, but also as the body which has got to manage and approve the legislative body of work that's got to be implemented in order to respond. And therefore, emergency planning must take account of the role of the legislatures, because that affects how the response to the pandemic can unfold, and it has important time and resource implications. So we suggest that all 4 legislatures should have some role in future planning. And with that, I'll leave it there. Thank you.
Well, thank you, all of you. I think I'm going to thank the audience as well. You've sat here for over an hour. When I was an academic, it was said that you couldn't expect people to listen to anything for more than 50 minutes, so you're all
so they switched off when I started.
doing very well. We did start a bit late, it's fair to say. Now,